A few weeks ago, the UK Supreme Court delivered a landmark judgment for the case of Lloyd and Google. It ruled unanimously in favour of Google and rejected the representative action of 4 million affected iPhone users. This marked a huge win for data controllers throughout the United Kingdom and spells a potentially critical blow for many data privacy actions. So, in today's video, we will examine the case itself and what exactly the impact of its judgment will be. The claim was brought about by Richard Lloyd, a former director of the consumer group which, as a representative of 4 million affected iPhone users, he alleged that Google had breached its duties as a data controller under the Data Protection Act of 1998 during the period of 2011 to 2012 by collecting and using the browser-generated data of 4 million iPhone users by using a Safari workaround. The question before the court was whether the claim could be brought at all in English courts, given that Google is a US headquartered company. The Supreme Court unanimously ruled in favor of Google. In doing so, the court rejected two crucial grounds upon Mr. Lloyd's claim was based. Firstly, Mr. Lloyd tried to demonstrate that the group of affected users all had the same interest in the claim. This was important because US-style opt-out representative class actions are not generally possible under UK law. They are only possible in A, a competition law context, or B, if the claimant demonstrates that each affected individual shares the same interest in the claim. In order to try to pass this test, Lloyd tried to disavow each class member's individual circumstances by asking the court to award the same amount of damages to each and every one of them. An amount of £750 was suggested, which, multiplied by 4 million members, amounts to a claim of £3.3 billion from Google. But the Supreme Court disagreed that a uniform sum could be recovered in this instance. It said that the same interest class action was reserved for rare instances where all the individuals of an action suffered exactly the same loss, such as being overcharged by the same amount. In most cases where levels of harm differ, each separate member of the class would need to provide evidence and be awarded damages for their individual circumstances. Mr. Lloyd wanted to avoid individualizing claims, as it was much more costly from a litigation funding perspective. Secondly, Lloyd tried to assert that the loss of control of data that the members of the action had suffered amounted to sufficient damage within the meaning of the Data Protection Act of 1998. Mr. Lloyd did this so as to claim the same uniform amount for all the claimants in order to avoid going into further detail of their individual circumstances. Individualizing the cases would be very costly from a litigation funding perspective, as they would need to provide evidence of the circumstances of each of the 4 million affected users. The Supreme Court rejected this ground as well, saying that loss of control of data was trivial, and the Act only allowed recovery for material harm, such as financial loss or mental distress. The court also stressed that claims that could not show evidence that the data controller made some unlawful use of data and that the individual suffered some damage as a result, were doomed to fail. So why is this judgment so significant? Firstly, claimants and their litigation funders backing existing representative actions may be in trouble. These may include a lawsuit against TikTok brought about by the former child commissioner on behalf of all young people, as well as a data breach claims against Facebook. In particular, if these claims seek to rely on loss of control of the data as a form of damage, then their claim may be rejected. They will have to reevaluate to ensure that their claims are still viable from both a legal and a funding perspective. Secondly, the judgment will make it harder for data privacy claims to succeed in general. The Supreme Court made it very clear that evidence of material damage or distress from a data privacy violation is necessary for a claim to succeed. However, this greatly increases litigation costs, especially for large group actions, and for that reason, claimants may find it difficult to proceed with such claims. Moreover, the court rejected the notion that loss of control in its own right can give a right to damages. The majority of data privacy claims are not for material damage, but for loss of control, as it is easy and inexpensive to claim. Without loss of control to rely on, and the need to provide evidence of material damage, there will be a lot less data privacy claims. Thirdly, it's more difficult for data privacy class actions to succeed. Litigation funders preferred claiming loss of control for class actions because it did not require individualizing each claim, and it was easy to show that all claimants suffered the same level of harm. With loss of control gone, there will be not many funders who are willing to fund such large class actions. Lloyd described this ruling as a blow to consumers everywhere. However, others have welcomed it. They say that if decided differently, the case would have opened the floodgates for litigation, for speculative and vexatious claims, which would have had far-reaching consequences for the public sector and large data processing companies. So what do you think? Is the judgment fair, or would you have reached a different conclusion? As always, thank you so much for watching, and don't forget to leave us a like, comment, and subscribe for more great content.